perspective, and over to Andy. Andy Slaughter, Shadow Justice Minister, and Andy's been deeply involved in tracking this this debate. Andy.
Yes, we've heard a lot so far this afternoon about text messages and whiplash and referral fees. And for those of you who are going to rush off and pick up the legal aid, sentencing and punishment of offenders bill, which is what I'm taking through committee at the moment for the opposition, will read that in vain to try and find any reference to those matters. We are now promised there will be something on referral fees, but as I think has been conceded, that's only in response to the very successful campaign that Jack Straw has run, and in doing and in announcing that very belatedly. You know, we're now at almost a report stage. We've dealt with part 2 of the bill. We've seen nothing on that, and the Minister has told us he's not sure what a referral fee is. So I think we can take with a pinch of salt what people talk about in terms of compensation culture and what is actually in this bill. I think the use of the term compensation culture has been quite insulting to people's intelligence over the past year. It's been an excuse, certainly, in the debates that I've had with the government, with the Minister. It's been an excuse for proper argument being put forward, and essentially it's a way of blaming victims. What I think the provisions that are in the bill, I'll come on to talk about the examples of the bill in a moment. What I think the effect of the provisions are in the bill are, is one, it's going to restrict meritorious claims. Secondly, it's going to make victims rather than wrongdoers pay some of the costs of bringing and winning cases. Thirdly, I think it's going to reduce the filters on unmeritorious cases coming forward, because solicitors, ATE, insurers, etc., do act as a filter in the way that people, chancers, as they've described, I think, who might bring claims, if costs are introduced, if one-way cost shifting is introduced, so there is no risk in bringing a claim, may well encourage nuisance claims to increase, which I can't see really why Johnson would be in favour of that. And I don't think it does deal with the abuses. Well, we know it doesn't deal with the abuses because they're not in the bill at the moment, except by closing down litigation generally. And therefore it has consequences, perhaps unintended consequences, as we've seen in the papers recently, to the Dowell family in bringing their action against Rupert Murdoch, consequences to, in cases like Trafigura, Shell, i.e. multi-party action, particularly in developing countries, against multinational companies in the UK, consequences for creditors who want to bring actions against insolvent companies, particularly when the directors have taken the money out of that, and consequences, and I'll say a bit more about this as we are at the Labour Party conference, in terms of employers' liability, in terms of both industrial disease and injury at work. I noticed the Chancellor said in the budget in March that no-win, no-fee legal services that prey on employers will be restricted. Well, what I took that to mean is that he's endorsing the stripping of rights from employees so they can't take action when the employers fail in their duty of care. And moreover, if they do prove that case, then they will pay a portion of their rightful damages in order to have brought the case in the first place. Well, you know, we've spent 100 years, the trade union movement spent 100 years, building up some of the safest workplaces in the world, and that is potentially at risk, because if you don't have the ability to hit bad employers in the pocket, then they are incentivised not to keep safe workplaces. And that is a feature of this bill, whether you look at clinical negligence, which both will do CFAs, but also legal aid, whether you look at the restrictions on legal aid, things like welfare benefit, it's going to permit or encourage poor quality decision making, whether that's clinical decision making or whether that's decision making about whether people are awarded things which they're entitled to. So we look at the bill, you've got part one, which is the legal aid cuts, which are targeted to take help away from the most vulnerable, and we have said that we oppose that part of the cuts. We oppose the cuts to social welfare legal aid, and we have suggested alternative cuts, which will be less damaging and which we believe will save more money in the long run, because the consequences of cutting legal aid are likely to be that you just store up problems for the future and expenses for the state in the future. Part two of the bill, which is what we're talking about now, principally clauses 41 at 43, is about stopping the recovery of success fees from losing defendants, and also ATE insurance premiums. I'm sorry if there are people who don't know what they are, but I don't think I've got time to go into to all the detail of that. It will mean that meritorious cases don't get into court because the system will be restricted. I don't accept, I'm going to come on just in a second to say why I think that a lot needs to be done to stop abuses in the system. That's stopping abuses in this current system, not chucking the whole system out and starting again from scratch. I'm not sure I entirely go, and I think in a way the ABI they make some good points, but they make them a little bit too strongly for their own good. I'm not sure whether there is a £2 billion whiplash injury, when I noticed in the Deloitte's report that they quote that the cost of all road traffic accident personal injury claims, including fees, is £821 million. I accept that the insurance industry lost £2 billion. I don't necessarily on underwriting last year. I'm not sure. I do accept that that's a consequence entirely of a compensation culture. I think it's partly a way that they run the business for that period of time, and partly a fact that they've had to top up their reserves for the first time. There are many other factors, and I think the fact that Nick won't say if you ask him that premiums will come down. And I think he's right. I'm glad he doesn't say that, because I think that would be dishonest, because there are so many factors that will affect the insurance industry. But you can't have it both ways. You can't then say that premiums got up because of the so-called compensation culture. I don't accept that all insurance comes to losing money. I spoke to the chief executive of Admiral, who were making, I think, a 28% marginal profit at the moment, and I asked them how they did that, and they told me because they run their business very well. Now, I don't know whether I don't know whether that's whether Nick or others want to respond to that. But if there's any truth in that, then I would say we should not, or those people who are victims of accidents in whatever form, or victims of tort fees in any form, should be taking less in order to subsidise an industry that isn't operating terribly well, and that perhaps they should put their own house in order before they do that. No win, no fee is introduced to help poor and middle income people get justice in the courts. I mean, exactly the people Ed Miliband was talking about today, grafters, people who work hard, not the people who skive at the bottom, not the people who profit take at the top. And I've given some examples. Let me just say a little bit more. I don't know if people saw the very courageous thing that the Millie Dowler's family did in going to the Prime Minister and asking him not to take the steps that are being taken in this bill, because without that, they felt they could not get justice. They would not have been able to get a case against Rupert Murdoch, and the case, not just a consequence for them, a consequence for all of us, because that is what brought the phone hacking scandal out, or what Lee Day and other companies have done in relation to cases like Trafigura. I accept, however, and I don't want to go on much longer, but let me just say this because it's the other side of the coin. I accept that claims management companies are out of control, and I accept that something needs to be done. And these are the sort of things I would like to see done. I would like to see ban referral fees in road traffic personal injury cases. I would like to see us looking at whiplash, as they have in other European countries. So, for example, and I'm not saying this is the answer, but it's one thing. What they do in Germany is you can't claim for whiplash if your car's going at less than 10 miles an hour. But I think that's something that needs to be looked at scientifically and clinically before we make decisions on it. Of course we should restrict the robocalls, the text messages, things of that kind. And one thing that hasn't been mentioned yet is personal data, the abuse of personal data, and the fact that that needs to be made, and perhaps referral fees need to be made as well. There need to be harsher penalties, either harsher civil or criminal punishments in relation to that. And we need to have better regulation of claims management companies, because the MOJ, which does it at the moment, is not doing a good job, and perhaps the Legal Service Ombudsman should be done that. But you can do all of that without destroying the current civil justice system, and you can end up with something which is better, which doesn't have fraud, that doesn't have abuse in it, without saying that we suddenly must have a completely different system only 15 years in to one that's been agreed. So, I mean, I will end there. I'll simply say that I don't believe all the arguments are on one side. I don't believe the arguments will be made at all, frankly. And it would be better if we had consensus on those issues which we should have consensus on. And we have to ask the question, why has the government legislated in the way that it has, or is proposing to, and has not tackled the clear and obvious abuses, which is what most of the panel have directed their attention to tonight.
Andy, thanks very much indeed. So, in today's